Ladies and gentlemen, have you arrived at a verdict? If you'd hand it to the bailiff, please, or the sheriff, please. All right, ladies and gentlemen, your verdicts are in good form and will be accepted by the court, and I'll announce your verdict in just a second. All right, ladies and gentlemen, in the audience, I am acutely aware that your feelings are on edge, that there's a great deal of emotion involved, and I certainly can understand that, and everyone that participates here can. But the court cannot tolerate and will not tolerate any verbal outburst, any display of emotion whatsoever. So you're cautioned and warned as I read the verdicts that you are not to show any outburst, any emotion, or any display. And I recognize that that's difficult, and that's why I'm warning you in advance. The verdicts read as follows. We, the jury, find Jessie Lloyd Misskelley, Jr. guilty of first-degree murder in the death of Michael Moore, signed by T.J. Williams, foreman. Is that your unanimous verdict, ladies and gentlemen? Yes. All 12 of you agree. Gentlemen, you want the jury to be polled on that verdict? Yes, sir. All right, ladies and gentlemen, we're going to go through a procedure called polling the jury, which simply means that when your name is called, if this is your verdict, answer yes. You ready? You have the jury list? I'm sorry, I probably didn't tell you. While the clerk's getting the jury list, I'm going to read your other verdicts. We, the jury, find Jessie Lloyd Misskelley, Jr. guilty of second-degree murder in the death of Stevie Branch. We, the jury, find Jessie Lloyd Misskelley, Jr. guilty of second-degree murder in the death of Chris Byers, again signed by T.J. Williams, foreman. Are those verdicts your unanimous verdicts? That is, all 12 of you agree upon each finding. All right. And in just a moment, when the clerk returns with a jury list, I'll ask her to call your name. And if these verdicts, all three of them, reflect your individual finding, then you should answer yes as your name is called. And while the clerk is bringing the jury list, I might explain to you that your findings, which the court has accepted, will require you to return to the jury room and consider the punishment. Before we do that, food has been ordered and it should be here for you. And I'm going to ask that you take a break for lunch. Take whatever time you need to rest and enjoy the food that's being provided. It won't be much. And after that, then we'll reconvene and I'll give you further instructions, and possibly, if the lawyers care to, there may be brief arguments or brief presentation of additional facts. That may not be necessary. It depends upon my discussion with the lawyers. So I'm going to let the clerk poll the jury at this time. So if these represent your individual verdicts, please answer yes as your name is called.
Carla Price. Yes. Stephen Green.
Yes.
James Rainwater.
Yes.
Teresa Burgess.
Yes.
Ronnie Smith.
Yes.
Lloyd Champion.
Yes.
Margie Woods.
Yes.
Donna Ludina Moore.
Yes.
Janet Luter.
Yes.
April Lunsford.
Yes.
Audrey Dacus.
Yes.
T.J. Williams.
Yes.
All right, ladies and gentlemen, your verdicts will be accepted by the court as the verdict in this case, and at this time you'll be allowed to recess, and I'm going to keep this area back here where you have coffee, cold drinks, and food coming. If you want to go outside the back to smoke, I'm going to provide deputies out in that area. That'll be fine. But you may stand in recess for, let's say, 30 minutes. Will that be sufficient time? All right, you may stand in recess for 30 minutes. Gentlemen, I need to see the lawyers.
I'm sorry.
That's all right.
I
I should have warned you.
We were locked in, couldn't get out.
Yeah, I should have warned you. Don't worry about it. Gentlemen, can I see the lawyers at the bench? I thought that's a reasonable results, basically. You know, I can follow their logic in those results. What I need to know from y'all. First of all, I don't.
You don't want to be. I don't know if you want to be or not.
No, I don't really. Okay, well this one's Barbara. She needs to hear. Yeah, Brent. I guess under our new law, you're entitled to put on aggravation or mitigation. I don't know whether it's really necessary with these findings, but I think that if you want to, you're permitted to do so. I'm not sure of the effective date of the new bifurcation.
I thought it was effective for crimes that occurred
after that. That's what I thought too. But now, so I'm not sure that it's even appropriate or applicable.
What they're telling us out of the prosecuting coordinator's office is that it's applicable to crimes that are tried after January 1st.
Which means that you could do aggravation or mitigation.
Right. The biggest thing that, there is an instruction that they prepared that instructs the jury on parole eligibility and that sort of thing. I hadn't even given that any thought.
Well, that's why I took the recess, because I haven't either, and I hadn't even read that material. I'm sure most of y'all had, and I was on the
discussed this matter with several attorneys, and it was my understanding that we had the option of opting in or opting out.
Well, that's kind of what I thought too, but I don't know.
We want to opt out. Just go to the old system.
Opt out since the crimes were allegedly committed.
I'm not familiar.
Well, y'all want to do a little research on it and call and find out what you want to do, and just let me know whatever one of you wants to do. Then, hey, now, by the way, do y'all have any verdict forms that fit this situation? Because I'm not sure you gave me any.
I don't think that's going to get entered today, Your Honor. Quite frankly, I don't think we have one written.
We got a book. Let's go get some.
Well, I need verdict forms too that provide for.
Okay, I don't have any prepared.
Doesn't matter. Type it up. We get a type it up.
Okay, all right, Your Honor.
What is the class B? Two class B?
In a Class A. Just let me instruct that the range of punishment on first-degree murder is 10 to 40 years or life.
Put on some argument, it'd be real brief.
I don't want to.
Well, that's why I want y'all to find out. I won't find.
Well, even if that doesn't apply, you've always got the right to argue punishment.
Yeah, we didn't have the right to until.
No, we would submit that under the existing law at the time these acts occurred.
Well, but I think since it was bifurcated, I think you're both entitled to a 5 or 10 minute argument as to what the appropriate punishment is.
Because that wasn't agreed.
But they didn't come back with a conviction on capital murder.
I know, but you neither of you have really argued the law as to punishment in any of these things.
We'll look at the law, Your Honor.
Okay. Well, sandwiches, y'all don't need to leave because I ordered 99-cent quarter pounders for you.
I just need like 4 or 5.
We can't leave.
Well, yeah, if you want to, but I mean, I told them 30 minutes. I can keep them out an hour.
30 minutes to eat?
Yeah.
Oh.
40 of them. They were just 99 cents. Hell, that's the best deal we've had. No, not really. You know, and really, I can follow their logic. Their thinking was that he directly contributed to the death of the Moore boy, and indirectly to the other two, and that's not completely inconsistent with the facts. You know, I mean, I can understand it. And they probably decided that we're not going to consider capital because You know, the only thing they had is his own confession. And that's, you know, I think those verdicts are logical.
Right down the line, man.
Is the new law codified in the criminal volume? Anybody even know where it's codified?
No, I don't. I'm going to be honest. I got something in the mail about a new proposed instruction. I didn't even bring it with me.
It's my understanding, Your Honor, that it applied to...
Call that thing in that office that they established up there and find out what their thought on it
That's
is.
the resource center?
Yeah.
You got a number for that?
What John was saying is they didn't argue.
No, they hadn't. I'm going to let them argue punishment. I'm going to let you argue punishment anyway because you haven't done that. I'm going to give you like 10 or 15 minutes each. But now, as far as calling victim witness, well, maybe what they want to do. That's what I'd do.
I don't think anything we can argue now is going to make it difference. And I don't think anything we argue now is going to make any difference. They've been back there for 12 hours, 10
Well,
hours.
they need to have it explained to them what it is they're doing.
I think you need to understand the range of punishments.
That's what I'm saying.
As far as doing a bifurcated mitigation aggravated, we would object to that and say that that's not the law that was in effect at the time of the murder.
Yeah, but that wouldn't have anything to do with punishment, just arguing punishment, because you hadn't done that technically. You know, they weren't supposed to even consider it, and y'all didn't. No, we would have done the same thing under the old system. If they came back with a lesser included offense, you would argue punishment. I've done it before. You just argue punishment. You don't bring on evidence.
Or you're going to call witnesses.
Yeah, I didn't see his reaction at all. What did he have any reaction?
I wasn't looking at it. I didn't see it.
Are you disappointed with that verdict?
Yeah, a little bit, but I think it was...
Boy, it was probably compromised.
Well,
But
yeah, but I think that what they got hung up on is saying, well, you know, he said this is all he did, and thinking they couldn't go beyond that.
well, I think that's probably true.
No.
I think that's probably what they did do. Is what I'm saying.
And what I would have argued maybe is, you know, ladies and gentlemen, just suppose that we didn't have a confession, and all that we had was a fingerprint, this defendant's fingerprint on the neck or on the shoulder of one of these kids. Would you expect to say he's not guilty or guilty of a lesser offense simply because we couldn't show exactly what he did?
Yeah. Well, the other thing is, and I thought you argued it was that just because he said that's what he did didn't mean he didn't do more.
Yeah.
Well, I mean, that was the argument. That's the argument you made.
There's nothing in evidence to suggest that.
Sure. Then you got three werewolves, you've got all kinds of things.
Take it off.
I mean, that would be like saying if all you had was evidence that put the person at the scene of the crime, that you couldn't convict because you wouldn't know what he did. And that's not... I mean, Judge Burnett did one where all you had was a thumbprint on a... Hogan,
wasn't it? Yeah.
That's all he
It's
had.
the only evidence we had.
On
We
a
had
thumbprint.
some vague circumstantial evidence of a witness that claimed they saw a man that fit his description at a convenience shop in Memphis at the same time the victim was there.
And this guy went to the penitentiary with a...
Yeah,
What-
went for life without parole. Yeah,
How could you guys sleep at night?
I was just good.
Didn't have any problem at all, huh?
No, I didn't, as a matter of fact.
The perspective of...
This
where you
guy
are
was
in life.
bad news. He was, that was the case where we had that piece of cable tie,
I remember hearing about you beating on the jury
and
rail.
I would bang down on the jury rail, and he'd go wham, and they'd jump back, you know, and says, as he beat her unconscious.
They had the obligatory, what did both sides think about the process?
The process. I'm a believer in the American justice system.
Let me wrap myself with a flag before I I don't have any coming there right now. I'm just throwing out what I think.
I'm going to save it for you can't give me a sentence. You can give me a sentence. Then we can.
You know, it probably wouldn't be appropriate for me to comment since I've got another one to go.
Yeah, that's right.
Yeah, and also they haven't fixed punishment yet, and that's an integral part of the process. So probably it's a little early for them to either be elated or discouraged, or ambivalent or indifferent. And John's right. He and I can't make any comment because there are two co-defendants yet to be tried. So I don't want to comment. You know, the jury heard it and announced their decision. That's all that matters to me.
Is that the new code? The one that just came out?
Yeah, I'm confident that's
Yeah.
Did I give y'all enough time to get hooked up?
Yes, sir.
Is there any disturbance outside? Any problem? On a feeding frenzy. They love.
I think comment on any others who get another trial. Off the record, I wouldn't go through the trial. Well, no, I wouldn't sure somebody was trying.
Well, Barb, here's one that we just got, another murder case we just got affirmed on. Maurice Coleman, do you remember him?
I remember somebody got a 7-month extension that he didn't need. That's what I remember about that one.
I'm in trouble. I shouldn't have mentioned this one. That was Bill Ross's case.
Well, of course.
Yeah, he's the only one I ever give extensions to, isn't it?
Well, why do you do that?
Did you hear about the murder case Fred just tried? Got
Yeah, I heard.
life and some juror saying that it was only 8-3 or 8-4, 9-3, and they filed some kind of affidavit asking for a new trial. The jury said it wasn't unanimous.
Well, Sam might grant it. You know, poor Fred.
I know.
Did you say about a recess? I didn't know.
I gave the jury a 30-minute recess.
Probably going to be long.
It's probably going to be longer than that because none of us really know the status of the new procedures on mitigation, aggravation, victims' witness impact statements, and all of that sort of stuff. You know, we knew how to handle it if it was a capital murder finding because that you've got strict instructions to follow on that. The question is whether or not they get to put in additional evidence or not. Now, they're going to each get to argue briefly their version of punishment. But whether or not we take additional testimony depends upon how we decide, how I finally decide the new law, whether it's applicable or not. If I decide that it's not applicable to this case, then the lawyers will get a few minutes to argue punishment, and I'll simply read a statement to the jury that the range of punishment is X number or whatever, you know.
So you still have to deal with that.
Huh?
You still have to deal with that.
Yeah.
Are you going to do that out here? Or
Sure, right. Oh, yeah, right here.
But do you think it'll be longer than 30 minutes?
Yeah, I really do, because we're having to call there's two theories of thought. Whether or not, one is it applies to trials that occur after January the 1st, or if it only applies to trials that were committed after January the 1st. I think it probably means anything that's tried after January 1, they can do additional testimony if they want to. Because all of our trials are going to be bifurcated. I try to explain that to you. The reason for that is to allow the defendant to have the opportunity to put in things that would have otherwise been inadmissible to mitigate the crime, and to allow the state to put in things that would have been prejudicial and inadmissible to show that the person had either a history of bad acts or a proclivity to crime or things of that nature. Plus, victim impact statements will be allowed. And none of us really know whether it's applicable to this case because it occurred prior to the passage of that bill and so forth. So, but in any event, they'll get to argue punishment because that hadn't been done.
I figure first degree murder, what's the range of
10 to 40 years or life.
If each one of these folks out here are saying, the parents of these victims are all saying they want to say something to the jury, are you going to limit it if you do allow victim impact statements?
Well, if I decide that they're applicable, then I'm going to leave that to the lawyers. I don't dictate what they put on, what they don't put on. I mean, how in the world can the judge be the one that decides who gets to, make a statement to the jury? I mean, that'd get a little out of hand. That's got to be controlled and handled by the lawyers involved in the case. And I'm not going to. I'll either permit it or not permit it.
In looking forward to the next case, is there any...
Am I looking forward to it? Was that a question? Not.
Is there any way before you get to actually presenting the information on the sentencing, before you go to the sentencing phase, you could, an agreement could be reached with the defendant to lessen the sentence and return for testimony in the next trial. We talked about this a little bit yesterday. Or is that something that isn't even being done?
That's something you need to ask the lawyers about.
Is that a possibility?
Am I being quoted on this?
I'm trying to find out what the process is.
Well, not for the record. I assume that could be a possibility, but it wouldn't be within my purview or my prerogative to say one way or the other. That'd be something that they'd have to initiate and they'd have to do, and then they could approach the court with it. And yes, that's a possibility.
They'd have to do that before they make
They'd
their
have to,
arguments.
they'd have to do that, and they'd have to come to me, and then the court would have to ratify whatever their agreement was, and then you could proceed. But my speculation on it, and again, it's not for the record, is that's very unlikely.
That they what?
That's very unlikely to be what I... Would you,
Well, no, I don't know. My editor's asking questions, so I'm sitting here.
There are 1,000 different variables that you could come up with.
What are you drinking, Judge?
Diet Coke, I've got one.
We'll get it.
Oh, thanks. Did that work out?
As far as I know, everybody was happy. We had you live in Memphis. I know Jonesboro had you live. So thank you very much.
Okay, y'all got it fired up and sent off.
Oh yeah. We'll probably do this penalty phase and then get out here. We will be here with you in Jonesboro, so we'll probably see you in a couple of weeks. Thanks a lot.
Y'all gonna get me eating a cheeseburger at the bench now. Man, alive. You're gonna make this look like country justice or something. The judge eats a cheeseburger.
You're reading it, Wilmer. What is it? Any personal feelings or?
I don't want to comment because there's another trial, and it wouldn't be appropriate for me to make any comment, particularly when I'm going to be presiding over another trial or essentially the same occurrence. So, even though you are going to be printing it way down the line, that's true. Somebody might subpoena your recording.
Were you surprised, or just as a judge, from what you heard?
No, I wouldn't say I'm surprised. In fact, I can understand their rationale.
I think it's too early to say. Probably know what the face can do.
If you look at how the findings were, you can pretty well interpret their reasoning.
What else? What do you think of the verdict?
So, what more can I say?
Eat. Give me a slate.
They do it. Thank you.
Do you know where the Misskelley family went, or is it just...
No, I don't have any idea. Did he say or do anything?
I don't know where they went.
Oh, thank you, sir. No, I'm fine. Thank you. That's a good deal, wasn't it? 40.
Those are 99 cents a piece.
Any thoughts, Mr. Sheriff Staff?
Any thoughts?
I know you have many.
I'm glad it's over, and I'm real proud of our judge. I think you've done a fine job. I'm real proud of it.
Good security.
I think the sheriff
did a fine job.
I think the sheriff's done an outstanding job in organizing the security. I'll give him credit where credit's due. Are y'all really gonna film me while I eat this thing?
Take a bite.
It's like chewing gum. I've got this little piece of cheese on my finger that I want to lick off, and I can't do it while you got that camera on. How in the world can this fit into a documentary? Are you going to make us look like a bunch of homespun bumpkins?
No, sir.
You promise.
I promise. Any thoughts about this? You're out. I don't. We have no film now to give you thoughts.
Brent, tell me what they told you.
Well, what Karen said is that the case of Andrews B. State is a 60s case that said that parole information regarding parole eligibility is not it's not proper to present that to a jury. And she said, of course, that's case law. She said, now the legislature has come in and said, among many things that you can now present, you can present that information to the jury. She says the question is, when that issue is
the court decided it's
to the Supreme Court will say, well, we still, that's our case law, and we don't care if the legislature.
No, we would just admit that this was a product of the act, and we just need to advise the jury to raise the punishment and let them make the decision.
Well, now,
what did she say about victim impact statements?
She said that's all. She said the question of whether the fact that this crime occurred prior to the effective date of that statute, she said that's not an issue. She said it is clearly that statute governs. She said the only question becomes what is appropriate. She said,
why don't we stay away from parole eligibility?
She said the only negative aspect of that would be. She said if now after the penalty phase, if they come back giving 5 years on each one of the second degrees and 10 years on first, and she said then I'm probably going to look like mud in the paper because somebody's going to mention that there is legislation out there that allows you to present them what their eligibility is. She said, of course, if it gets reversed, you have to come back and retry the sentence.
It ain't worth it to me, in my opinion.
It didn't me either.
So you want to put on victim impact?
I don't think our victims want to do that.
Well, I heard that the newspaper people came up here and said they all wanted to say something. I hope not. I hope you just get to argue a little bit on, let me instruct on the range of punishment, let you argue, and then go back and let them do it. Did somebody get me a verdict form made?
Well, the facts in the standard verdict. Are y'all working on the standard?
The range of punishment everything that you for a long time. I don't want anything that affects other tribes about it. But what's the next
Yeah, really? Well, they're satisfied with it, aren't they?
He said, I've been a miser at them. He said, Dad, we're going to speak to him. What he's going to do. So be quiet.
You're probably right.
I'm like, you said,
We were rejected stringent for that.
What's that? Y'all are hell bent to get me chewing a hamburger. But can't you see this in a documentary that hayseeds eat cheeseburger from the bench? I guess I ought to drink a different kind of soda too, I ought to switch,
What's your favorite meal after the verdict?
Go ahead and say it. You might get a wrong.
Boy, I don't know. It's not a cheeseburger. There's not any trouble or anybody even the other family. Look, well, don't step on that mustard. I see there, man. Where are they? Misskelley. Are they upset or carrying on? They expected it.
What about separated him? What about separated him?
Well, is somebody making me a verdict form? Or verdict forms?
Well, we're not yet.
Who's Mike?
Probably.
I'm trying to find numbers for the resources center.
Well, all I need is one that shows a range of punishment and a place for a finding.
The jury instruction book is in the clerk's chamber of law. I don't want to big tape.
You can start it off like this one in here. You have found Jessie Misskelley Jr. guilty of first-degree murder. It's now your responsibility to fix punishment. You are instructed that punishment for first-degree murder is 10 to 40 years or life. And then you have a blank for their finding, the signature line for the form.
I thought I even prepared one of those.
Well, if you did, I hadn't found it.
I probably didn't submit it yet.
Maybe you did. Let me look.
I think I did one of those in the file. With me and our jury instruction subpart. The jury instruction file.
Your briefcase in the car.
Okay.
Well, y'all didn't give it to me if you did.
No, I didn't. I don't think. I wasn't sure how it was going to work, so I didn't.
Do you feel relieved? Do you feel relieved? Well, I think y'all ought to feel like you did a damn good job. Don't you, Larry?
Yeah.
I'm serious.
I'm ready.
That's not past constitutional muster yet. I don't want
I don't want to do it either. I'm trying to suggest to them that we just needed to argue. I may take care of that for you. Don't worry about it.
Thanks, Judge.
Yes, dear. Done what?
I personally think that the whole law applies in this situation. It's not the date the act comes into effect, it's the date.
No, this is substantive law, though. And it's whatever's in effect at the time.
Right. So the fact that they got this new bifurcation for all trials starting January 1st shouldn't affect that.
Yeah, I think it does. That's what I'm saying.
Oh, you think it does?
Mm-hmm. It is now the law that's in existence. Did you get a sandwich, Mike?
Huh?
Back to back.
There's one right there.
Barbara got it.
Well, we forgot to get him.
Brown is back.
Probably.
Let's go kill a hog next week and do this one. And go to Squire.
It's not just that easy over there if you ain't got any dogs.
About a sack of corn.
But I know where some have been running. If we put some corn out, you probably get them in there.
Yeah. I can smell it corn.
Mm-hmm.
I might throw some apples and stuff like that.
Well, you need a pretty good sized sack of corn. Put it out a day or so before you want to hunt over it.
Cut it right there.
So we go over the see if I still got some much left of the water table that maybe is there.
I won $360 over there playing blackjack a couple of Saturdays. The only thing to put the damn slot machine and pass it out of the window. I ended up going home, $40 left. I went over it
I think he were over there that night that Gibson went over there and was winning, and I was getting his money out about as fast as he'd win it. Kept telling him, "Oh, hell, that ain't yours."
I'll tell you what, old Crow is. He's pretty tough. I looked over there one time, he was betting $100 a hand. I about passed out, fell out of my chair. And winning.
No, nothing venture, nothing gain. That big win, big or little.
Is he working on those jury instructions?
He's working on that. I think we got them in the file. We prepared everything down to manslaughter, I think. And I've just forgotten. You could, if you just give him that aggravator battery.
They probably would have given that in addition.
The gas after the DWI-3 instruction.
Did everybody leave, or are they going to stick around for sentencing? I mean, for...
Over and there and everywhere.
Were you surprised?
No. Not really.
Think it'd be higher, more?
As far as higher count?
No, did you think it'd be capital murder?
No.
Were you surprised?
Murder? No. Please go out and find somebody that was surprised, so I at least know there was.
That's why I'm telling you, I think y'all ought to be pleased. You did a good job. I mean, I don't think there's any question that was appropriate based on the evidence.
I mean, what I thought, it could go either way on guilt or innocence, but if he was guilty, that's what I thought he would get.
That's exactly the way I felt.
I mean, there was so much doubt. Anything that put him at the scene, I would have said, yeah, but they had
They did. They had his own statement.
Other than his statement.
How many trials do you have where you've got the witness himself or the defendant himself that puts him at the scene of the crime and puts himself involved in it? Damn near zero.
Well, I worked on a Henry Lee Lucas case in Texas where he confessed to all this, and they took him around and solved all these cases, and then turned out he was lying about every one of them. And I keep thinking about that.
Yeah. But,
what county do you live in? What county do you live in?
Now, but I work in San Antonio.
We should have changed the venue.
San Antonio, Bear County.
You had to be barred, I'll stay with you.
Hey, good Mexican food.
I thought there was a lot of that. I mean, it'd be hard for me to say.
I couldn't have decided. I'd been hung if I'd been on the jury.
Really?
I would not have been able to decide.
I had to have more proof so I could convict anybody.
Well, but you did have physical evidence that linked the co-defendants. Which
nobody was accusing those guys.
Well, but that link corroborated what the man said. And that was physical hard evidence that linked them to the scene.
The evidence that they think they got is not as good as anybody thinks.
Well, because the boy had made conflicting statements, but the same thread of testimony was in all of them. I think maybe they were saving it for the next trial. What do you think?
We were hoping they would, because after I heard his
Well, I think that was what made him break down and tell him what he did. He heard his friend's voice, and he told the friend something that was incriminating, and that the jig was up.
How did they have that so ready for the interrogations? I mean, also they had the tape, and they used it.
Well, they already had interviewed that little boy before.
Had they used it on other witnesses?
No. They had interviewed the little boy the day before, the afternoon before, and he'd given them information that Misskelley knew something about it. So they brought him in to find out what he knew. And then he knew when he heard his little boy's voice that he had told him things. That's what I think. Now, I don't think it was coercion. I think the shock of knowing my friends told him what I told him is what scared the shit out of him.
Plus he told some more.
He told other people too. And they,
Well, that must be some type of amateur circuit. I didn't see anybody look like that. They weren't big enough to do this. I mean, they were.
What was the quote? They couldn't fight the gnats off their ass. Did anybody run there? I didn't see it, if they did.
We didn't run it.
We ran it.
Pulled it out.
together in the state.
Brent?
And they were arguing back and forth. Finally, he goes, Your Honor, could I think it's, can I ask a question? He had on kind of a cowboy shirt, black and white, striped shirt or something. So he had a few words.
Hey, did you have them? There should be a little transitional thing that says you have found the defendant guilty.
I don't have a transition.
Okay, well I can make that up.
I mean, that's kind of obvious too.
I think I may have that somewhere else. What if we did one of those, like I did put count 1, count 2, count 3, did, and we made 2 copies of the one with the B. Just make another copy of it. The other ones.
You want us to copy them before you write on it, Judge, or a copy for each count?
Well, we didn't number the counts. What I need to do is add in here the names of the defendants. You know, like get one verdict form. We, the jury, having found. Can you get somebody to type them up?
Yeah. Vic can type them.
Okay.
Not for long.
Another quick dumb question. The sentencing, if he's convicted on 3 separate counts, are those going to be, when the sentences are announced, will they be concurrent or will they run?
That's discretionary with the court. Let me show you, Greg. I couldn't write it in here. It's we, the jury, having found Jessie Misskelley Jr. guilty of first-degree murder in the death of Michael Moore.
Okay.
Fix his sentence at.
Okay.
And it'd be the same thing on these, except you.
Oh, good.
Yeah, it's hard to. You do the exact same thing on there. You just say instead of firing, having found him guilty of second-degree murder in the death of, and then one for each of the boys.
Okay.
Okay, and then I'll give them a little transitional thing saying that.
Cheeseburger. What's your third or fourth one there?
That was my first one.
First cheeseburger. A little mustard relish.
2 weeks I was over in Boston. I never thought I'd miss a McDonald's places like that. Well,
I spent 2 weeks in Japan. It was pretty quiet. I thought it was hard. Finally made it to Tokyo. We were walking down the street and all the whole way to McDonald's. We got stuck in the door trying to get in there at the same time. I think he was hanging around. This was more like Japanese food. It really well Taiwan. They just had to cook everything. So it's like
the ones you do were skinny and running fast.
Glad you said something. We didn't even know.
No problem.
What's that?
The lady that came up behind the Misskelley's after the verdict, we don't know who she is. A family member of a different family.
I didn't seal that. I thought everybody handled the announcement real well. There wasn't, I guess I warned them enough that I was.
The reporters outside were all saying,
Misskelley never flinched. Never flinched.
He said that, you know, when it did really work, it was just kind of, he played it down, so it made it so it didn't get out of hand.
Yeah.
Well, that's not,
Well, I thought my announcement was necessary.
We do it either way. It could go either way.
And since you couldn't show, you don't show the jury, it's worked out great for us. Did you watch Jessie?
I couldn't see him. Didn't bat an eye, did he?
He knew he was going.
He told him last night that he thought he was going to get the death penalty. Isn't that what he said?
I think he was relieved when
He really did make those statements back there to him.
very coherent.
Yeah, about he's the one that knew what happened. That damn prosecutor didn't know. Isn't that what he said?
Well, see, I can use saying all kinds of shit to grow in them during their testimonies.
Oh, he was supposed to, because yesterday, actually brought him in and he was rubbing his neck. He said, my neck is killing me. I said, well, why don't you sit up? He says, I can't. So, he told me not to raise my
Yeah,
head.
that happened too. Did you hear him say that?
No, I just...
Well, they did say, they said he said...
Over several times, they would be testifying about things that happened at the scene. I didn't say, no, it ain't right.
Well, I mean, he must have known.
Yeah, there ain't no doubt about that.
Can you imagine what it would have been like to have him testify?
Oh.
Hey. I don't know. It could be 5 minutes, 10 minutes. You mean my part of it? It ain't gonna be very long. But you know how long it takes the jury, that's another matter. They're gonna be told that there's a fixed sentence on first-degree murder from 10 to 40 years or life, and on the 2 second-degree murder counts from 5 to 20 years. All right, court will be in session. And ladies and gentlemen, again, I seem to have to be thanking you for your patience. That 30 minutes I indicated to you turned out to be a little better than an hour, or more than that. And I do appreciate your indulgence on our delays. I might explain to you that the delay was absolutely necessary in order to allow the attorneys an opportunity to discuss whether or not they needed to produce additional testimony or evidence, which they would have been entitled to. However, I'm informed, am I correct, gentlemen, that each of you just choose to do a brief additional argument and proceed? Is that correct? And you've consulted with the family members, with your clients, and with anybody that might be appropriate at this time? Have each of you done that? Yes, and you're satisfied that arguments are all that's necessary? Yes, all right, ladies and gentlemen, you have found Jessie Lloyd Misskelley Jr. guilty of first-degree murder in the death of Michael Moore, and found him guilty in of second-degree murder in the death of Stevie Branch and Chris Byers. It's now necessary that you listen to additional arguments of the attorneys, which I hope are confined to about 15 minutes aside, and then again retire and fix the sentences for each of these offenses. And you are instructed that the range of punishment for first-degree murder is a term of not less than 10 years nor more than 40 years or life in the Arkansas Department of Corrections. You are further instructed that the range of punishment for second-degree murder is a term of not less than 5 years nor more than 20 years in the Arkansas Department of Corrections, or a fine not exceeding $15,000, or both a term of not less than 5 nor more than 20 years in the Arkansas Department of Corrections, and a fine not exceeding $15,000. After the lawyers do their additional arguments, then will read the verdict forms that you'll be asked to consider and complete. All right, gentlemen, you may. How much time do y'all want? 15 minutes? Cutting you too close? Do you want to split? You're going to split your arguments? Okay.
Ladies and gentlemen, and I'm saying this with all sincerity, I know what a difficult decision y'all had to make. This case is very emotionally draining for anybody who is a party to it. Whether it's the victims' families, whether it's the jurors, whether it's the court reporter, anybody who has to view these photographs, who has to hear this testimony, it is a gut-wrenching experience. And we all the time hear people criticize the jobs that jurors do, but I want to tell you that we thank you for being willing and able to go through this process and to do your civic duty in serving on a jury, listening to the evidence, and rendering a decision consistent with what the law required. Now you have to determine what is appropriate punishment within the range allowed by the law to fit the crime that you found that this defendant committed. In the first count, you will have the option on first-degree murder for the death of Michael Moore. The ranges, you'll be given a verdict form that shows 10 to 40 years or life. And you can fill that form in with anything from 10 to 40 years, or you can put life in prison as the appropriate punishment for what this defendant did. When you make that determination and you determine what is appropriate for the crime he's committed, I would just ask that you think back again, and I know it's hard, but in fitting the punishment to the crime, you have found that he purposely took the life, he or an accomplice took the life of an 8-year-old boy. And remember, the evidence was that the beatings had already started. Damien had already started to hit the one boy when Michael Moore took off. And but for the actions of that defendant who sits right there, Michael Moore would be alive today. And he brought him back to his ultimate death, the death of an 8-year-old boy. And I put to you that appropriate punishment for someone who does that, who takes the life of an innocent 8-year-old under the circumstances that we know by the physical evidence what happened to him, that merits a life sentence. I can't think of a case that could be more appropriate to give the maximum sentence than the circumstances surrounding this. The other two charges, which are Class B felonies, that you found the defendant guilty of second-degree murder, carry 5 to 20 year sentences, anywhere within that range, and there's also an option of a fine. Frankly, in this case, with the taking of 2 lives, I don't think a fine is even an appropriate consideration, but that's up to you. In regard to those 2 boys, just remember, in finding this defendant guilty, you had to determine that he went out there with the intent to inflict serious physical injury on those 2 boys, that he or an accomplice acted with that intent. And think back as to what injuries those individuals suffered. And I know it's something that as soon as you leave this courtroom, you'll want to shut out of your memory as much as possible for the rest of your life. And I do too. But when determining what is appropriate punishment within that range of 5 to 20 years, think for a little bit about the agony and the torture that those boys went through that afternoon. And that man right there, and ladies and gentlemen, he's a man. He's 18 years old. You found that he did it, and somebody that put those 3 little boys through what he was involved in, 20 years is something that is clearly appropriate. And I normally don't get up here and say, if the range is this, I think you should do that. I leave that to the jury's discretion. But in this case, I sincerely believe that what happened to those 3 little boys merits the maximum punishment you can give out on all 3 offenses.
And I ask you please to look back over that evidence, think hard, think long, and do what's right, and give a punishment that fits this crime and fits the 3 crimes, and give this defendant maximum sentences on all 3 counts. In asking that, I do that because not only what happened to the children, but what happened to their families. And they've been here, and you've had a chance to look at them, and you've seen them in the front row. And I don't think it's inappropriate to say, when you're determining what is the punishment, to think about what the effect has been, not only in the taking of those 3 lives, but what impact it's had on the mothers, the fathers, and the other family members of those 3 boys. And when you think about those things and you look at the evidence, I think it will be a clear and easy decision that the maximum punishment, although it's something that's a heavy responsibility to deal out, particularly to somebody that's 18 years old, I think it's clearly appropriate, and it's something that you can feel that you've done something right in regard to having the courage to give out that type of punishment for this type of crime, so that people who see what the punishment is in this case can say that that fits what this defendant did. Thank you very much.
Are y'all going to submit, or are you going to do it all? Do it all, yeah. Ladies and gentlemen, jury, Your Honor, Mr. Provost, Mr. Davis, I want to thank y'all too for your patience and your willing to serve on this jury. It's been a hard 2 weeks for all of us. I would thank y'all very much for your willingness to serve and to pay attention and to be here. Without y'all, this process would not have been possible. Obviously, from your findings, you have found that Jessie was at the scene. When you go back to that jury room, I would ask you to consider a few things. First, please consider what Jessie said in his statement. Please consider what he said he did and what he said he didn't do. Please consider all the circumstances. I'll also ask you to consider the age of Jessie. The prosecutor talks about him being 18. He's 18. He was 17 when the crime was committed. Now he's 18. I also ask you to consider not only his physical age, but his mental abilities. We've heard testimony that Jessie reasons in the round of a 6 to 8 year old. He certainly can function in society to some extent, but he does have certainly some type of mental deficiency. I ask you, chronological age doesn't always tell the whole story, ladies and gentlemen. I think each of you know that. I also ask you to consider his family background. We have mental health. You've heard bits and pieces of his family background. Came out through some of the expert witnesses in the testimony about his mother and his father. He's raised by his father and his stepmother. Some of the other family history he has. I ask you to please consider those factors too. Most importantly, though, ladies and gentlemen, I want you to consider what was Jessie's intent. You've taken to believe the statement, but I would please ask you to consider Jessie's intent. Read the statement again. Consider what he himself intended. What he himself intended as opposed to what an accomplice intended. Or I ask you just to read and consider those elements. As Mr. Davis pointed out, there's a range of punishments. The state of Arkansas has decided that when a person has committed the offenses that you have found that Jessie committed, that it's possible to impose. For murder in the first degree, range of punishment is 10 to 40 or life. I would please ask you to consider all the range. I'm not going to stand up here and tell you it should be one, or it should be the other, or it should be anything. But I am going to ask you to please consider all the range. For murder in the second degree, ladies and gentlemen, as Mr. Davis pointed out, the range of punishment is 5 to 20. And there's also, of course, the fine. I would ask you to consider the full range of punishment. When you're considering those things again, think back to the statement. think about what Jesse did and what he didn't do. To go in and not pay attention to such details, it's a difficult situation for us all. It's been a hard 2 weeks. Please review the statement again. Review what you've heard. Consider what did and didn't happen. Consider what Jesse did and what he didn't do. I will trust you to come back with the proper verdict. Thank you.
No. Okay. It should have been, but I don't remember giving it.
Ladies and gentlemen,
They're going to have to consider the facts again. This should have been read initially. I didn't realize I hadn't done it. If you're objecting to it, then I won't give it. All right.
it's almost over for y'all. In about a month to be over for me. But for the Moores and the Branches and the Byers, it's not ever going to be over. What this is talking about is responsibility. And you heard the defendant's own expert say, Warren Holmes, that it is common, it's usual for a person who confesses to a crime to lessen their involvement. You are not restricted to what this defendant says that he did. You're entitled to look at the evidence, all the evidence, the number of weapons, all the circumstances, the type of knots, and decide that he was more involved than what he says he was. If we didn't have a confession, let's say you didn't have a confession, instead all you had was a fingerprint of this defendant on Michael Moore's arm, would you say, well, oh my gosh, we don't know exactly what he did? No. I would submit to you that you'd be entitled, from all of the evidence in the case, every bit of the evidence, to look at that evidence and draw a reasonable conclusion from that evidence as to what this defendant did. Now, we know from this defendant's own mouth, in the interview before he admitted being there, that he had a phone call the day before from Jason Baldwin saying that they were going, their intention was to go and beat up some boys. He went there knowing that was the intention. And they went there and they did it. he refers to his borderline IQ scale. He's not retarded. He is not retarded. You've got the picture of the real defendant. That's not something that we're showing you, trying to make you mad at him or angry at him, to prejudice you against him. It's to show you that what you see is not necessarily what you get when you look at this defendant. It's not necessarily what you get. What you see is not, you can't always take everything at face value. And the experts testified that this defendant, how did he function? Not as far as book learning, but how did he function? Do you remember the testimony said that he functioned on an average level? His performance IQs, how he functioned, apart from verbal things and book learning things, he functioned on an average level. When you go back there and you consider the punishment, there are a number of things to consider. The punishment that would serve to deter this defendant from doing something like this again, and even more importantly, what effect will your verdict have on other people who might engage in similar type behavior? Is it going to be a message that, well, it's a bad thing, but it's not so bad? I don't believe that y'all could find that way. In this case, Michael Moore, he won't ever go to Scouts again. Stevie Branch and Chris Byers and Michael, they won't play ball. They won't play basketball. They won't play baseball. They won't grow up. Their lives are gone. But your verdict, it can't bring them back. Nothing you do can bring them back. And really, honestly, you look at it, nothing you do is going to make the families feel all that much better. It might make them feel good for an instant if you gave them the maximum, but it's not going to, in the long term, it's not going to make that much difference. But what can your verdict do? It can stop this kind of junk. It can stop these kids doing these stupid, crazy things, and it can put an end to it. And that's what we're asking you to do.
All right, ladies and gentlemen, you may now retire to the jury room to consider your verdicts with regard to punishment, and I'll read those verdict forms for you. The first reads, "We, the jury, having found Jessie Lloyd Misskelley, Jr. guilty of first-degree murder in the death of Michael Moore, fix his sentence at a term of," with a blank that you would complete, "not less than 10 nor more than 40 years or life in the Arkansas Department of Corrections," with a signature space for the foreman. You must unanimously agree upon the punishment that you complete in the blank. And whatever your unanimous finding is should be reflected in the blank provided, and then the foreman would sign. The next verdict form reads as follows. "We, the jury, having found Jessie Lloyd Misskelley, Jr. guilty of second-degree murder in the death of Stephen Branch, fix his sentence at," you have three alternatives, A, B, and C. A term of a blank, not less than 5 nor more than 20 years in the Arkansas Department of Corrections, or B, a fine of, with appropriate blank, not exceeding $15,000, or C, both a term of not less than 5 nor more than 20 years in the Arkansas Department of Corrections, and a fine not exceeding $15,000, again with the appropriate blank. In order to fix any punishment, your finding must be unanimous, and you would fill in the appropriate blanks that represent your finding. The foreman would sign. The third verdict form reads identically to the last, with the exception that this is for count 3 in the death of Christopher Byers on a second-degree murder charge. So you may now retire and consider your verdict with respect to punishment. right, court will be in temporary recess. All right, ladies and gentlemen, have you arrived at a verdict or verdicts, Mr. Foreman? If you'd hand it to the sheriff, please, or hand them to the sheriff. All right, your verdicts are in good form and read as follows. We, the jury, having found Jessie Lloyd Misskelley, Jr. guilty of first-degree murder in the death of Michael Moore, fix his sentence at a term of life in the Arkansas Department of Corrections. Signed by T.J. Williams, Foreman. Is this your unanimous verdict, ladies and gentlemen?
Yes, Your Honor.
Count two, we, the jury, having found Jessie Lloyd Misskelley guilty of second-degree murder in the death of Stephen Branch, fix his sentence at a term of 20 years in the Arkansas Department of Correction. Again, signed by the foreman, T.J. Williams. Is that your unanimous verdict, ladies and gentlemen? All right, verdict form 3. We, the jury, having found Jessie Lloyd Misskelley, Jr. guilty of second-degree murder in the death of Christopher Byers, fix his sentence at a term of 20 years in the Arkansas Department of Correction. Signed by T.J. Williams, Foreman. Is that your unanimous verdict, ladies and gentlemen? Questions, gentlemen? Do you want the jury polled?
Yes, Your Honor.
All right, again, ladies and gentlemen, if these are your verdicts, as your name is called, please answer yes.
Carla Price. Yes. Stephen Green.
Yes.
James Rainwater.
Yes.
Teresa Burgess.
Yes.
Ronnie Smith.
Yes.
Lloyd Champion.
Yes.
Margie Woods.
Yes.
Donna Ludina Moore.
Yes.
Janet Luter.
Yes.
April Lunsford.
Yes.
Audrey Dykes.
Yes.
T.J. Williams.
Yes.
Thank you. Any other questions, gentlemen? All right, ladies and gentlemen, with the thanks of the court for your consideration of this case, you'll be excused from further attendance and need not report back in the morning at 9:30, and or for that matter, for the next 2 years, you'll be exempt from jury duty. I thank you very much for your consideration of a difficult case, and one that obviously had ramifications that are not normally found in criminal cases. The attention, the pressure I know you went through, and I certainly appreciate your hard work and dedication, and thank you very much. I have been asked to inquire of you by the media whether or not you want one of your member to be a spokesman, whether or not you choose not to make any statement whatsoever. And I want to point out to you, you're not obligated to say anything to anyone about your deliberations. If you all would like to have a minute or two to discuss that before you depart. You have discussed it? All right. And what is your pleasure in that matter?
No comment. No comment.
All right. Then I'll certainly honor that, and I'll expect everyone else to. And you're not obligated to make any statement to anyone. So, with the thanks of the court, you're free to go, and I really appreciate your consideration. If you'd like, I can have officers escort you to your cars, and you're free to go. I want everybody to remain in the courtroom while the jury departs. Everyone, please rise while the jury leaves. All right, you may be seated. All right, Mr. Misskelley, if you could come around the front here, and Dan, and I need another docket sheet, a blank. Yeah. Yeah. Now, you want to just write on the blank one in the back, and then y'all move it. Yes. Yeah. All right, Mr. Misskelley, did you hear the jury's finding and the reading of the verdict in your case?
Yes.
Do you have any legal reason or cause to tell the court why a sentence should not be imposed at this time? You don't have to. I heard you, but you need to answer out a little bit louder.
No, sir.
All right. it's my responsibility and duty to tell you that you have a right to appeal your convictions in these cases. You must give notice within the statutory period of time. You have court-appointed counsel that can consult with you and your family in that regard, but you are notified you do have a right to appeal, and you're entitled to a bond on these charges. Do you gentlemen want an appeal bond fixed at this time, or because it starts your time running, or do you want to discuss that with Mr. Misskelley and his family?
I'd like to discuss that, Your Honor.
All right. Is there anything you want to say before sentence is imposed? You have a right to make any statement you care to at this time. You also have a right to have your attorneys make any comment in your behalf that you want them to. Do you understand that?
Yes, sir.
Your Honor, the one comment that we'd like to make is respectfully request the court to run sentences concurrently as opposed to consecutively.
All right. Well, I understand your statement in that regard, and of course that's a matter that addresses itself to the discretion of the court, and I'll consider that. Is there anything else you want to say to the court, or do you have any questions you want to ask the court at this time?
No, sir.
Are you satisfied with the service and advice of your attorneys through this trial?
Yes, sir.
All right. All right. Based upon the jury's verdict finding you guilty of first-degree murder in the death of Michael Moore, you'll be adjudicated guilty, and you'll be sentenced to the Arkansas Department of Corrections for a term of life. And in the count involving the death of Stephen Branch, the jury having found you guilty of second-degree murder, you'll be adjudicated guilty and be sentenced to an additional term of 20 years in the Arkansas Department of Correction. And in regard to the death of Christopher Byers, the jury having found you guilty of second-degree murder, you'll be adjudicated guilty of second-degree murder and be sentenced to an additional term of 20 years in the Arkansas Department of Correction. It'll be the finding of the court that all of those sentences will run consecutively. That is, you will receive a life sentence plus 40 years, and that'll be the judgment of the court. You'll be remanded to the custody of the sheriff for immediate transportation to the Department of Corrections. Mr. Sheriff, you'll be directed to forthwith take him to the Arkansas Department of Corrections and delivered to the proper custodian. And that'll be the judgment of the court, and this court will be in recess until February the 22nd.